Hello and welcome to Topic 8, Lecture 1. And in this topic, we're going to be learning about police and the rule of law. This is the second chapter that we're doing on the police. And in this lecture, we're going to be learning about searches and warrants. Okay, so what are we going to be learning about in this lecture? Well, first, we're going to talk about the Fourth Amendment and the two clauses in the Fourth Amendment and how the Fourth Amendment fits into the Bill of Rights and the other rights that are afforded to the criminally accused. Then we're going to talk about what constitutes a search. A search within Fourth Amendment law is very specific. It has a very specific meaning. So we'll talk about what the meaning of the search is. And then we'll take a look at the requirements that need to be in place for a legal warrant. All right, let's get started. So, in this chapter, and the chapters that we're going to read moving forward, really have a lot to do with the rights of the criminally accused. And the rights of the criminally accused come from the Bill of Rights. And so I know most of you know this, but we're going to review it anyways, that the Bill of Rights are the first 10 amendments to the United States Constitution. They weren't initially included in the Constitution, but they were a product of the agreement that the Federalists made. They said, hey, if you ratify this Constitution, states, then the first thing that we'll do is we will add a Bill of Rights because the states really wanted clear limitations that are placed on the power of government. And that's what the Bill of Rights does. And a substantial portion of the Bill of Rights deals with the rights of the criminally accused. That's a product of the experiences that the framers had as a product of colonization and preparing for a revolution. They knew what it was like to live in a society where there were no limits placed on the British king in terms of apprehending people, trying people, etc. And so that's reflected in how much of the Bill of Rights is dedicated to protecting the rights of the criminally accused. And so in this chapter, we're going to be taking a look at the Fourth Amendment and the Fifth Amendment. The Fourth Amendment deals with searches and warrants, and the Fifth Amendment for this chapter deals with the right to remain silent, and so that has to do with police interrogations. And then moving forward, we're going to be learning about the rights of trial that are in the Sixth Amendment, and the rights of those who are sentenced and the punishment that they receive, and that is the Eighth Amendment. So I just wanted to make sure we had a quick overview of that before we move forward. Okay, so we're going to spend a lot of time in this lecture talking about the Fourth Amendment. And the Fourth Amendment is the amendment that deals with privacy. There's this idea that one of the fundamental liberties that humans have in a democracy is to be free from government intrusion, that there are places in their life that the government needs a damn good reason for intruding upon. And the Fourth Amendment makes sure that citizens get a substantial amount of protection when it comes to what goes on in their private areas. And so the Fourth Amendment places limits on government power as it relates to privacy. And the Fourth Amendment does two things. It places limits on the power of the police during search and seizure, okay? And so that when it comes to arresting people, that police, there are limits in terms of the way the cops can arrest you, that usually you need to have probable cause and a warrant or an arrest warrant. Not always, but that's the Fourth Amendment is basically the arrest is a seizure. And so that people should be free from unreasonable seizures, and that includes arrests. There also, as you're going to see in the language of the Fourth Amendment on the next slide, that the Fourth Amendment says that people should be free from unreasonable searches, right? And so it places limits on the power of the police to search people and their property. And then also it places limits on the cops of when and how they can seize the objects that they're seeking in their investigation as a product of their search and on the contraband. And then the other thing that the Fourth Amendment does is it provides the legal requirements that are needed for a warrant. Okay, so let's go to the next slide and take a look at the actual language of the Fourth Amendment. So here is the language of the Fourth Amendment, and there are two clauses in the Fourth Amendment. The first clause is known as the reasonable clause. So the Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated." That's known as the reasonable clause. And I want to draw your attention to the word unreasonable search, okay? When the courts look at searches, the thing that they're looking for is this search reasonable? And that there's different ways that the court defines a reasonable search. Usually a reasonable search needs probable cause, but not always, okay? Sometimes it can just need reasonable suspicion. And so a search doesn't need a warrant. A search needs to be reasonable, okay? And so that's why it's known as the reasonable clause. Chief Justice John Roberts says the touchstone of the Fourth Amendment is searches must be reasonable. The second clause is known as the Warrants Clause. And so in the Fourth Amendment, it says, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And so in a way, the reasonable clause and the Warrants Clause are separate. The Warrants Clause is just saying that if you get a warrant, these are the things you need. But as I stated, you can engage in a search or a seizure without a warrant. And so in many ways, there's two distinct things that are taking place in the Fourth Amendment. So the Fourth Amendment reads, the reasonable clause reads, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated. So when we use that word search, what does that search mean? Well, search is used in the Fourth Amendment is not anyone looking for something, okay? Search in this context has a very distinct meaning. And so the way this word search has been defined by the Supreme Court over the years is that a search is a government agent infringing on a person's reasonable expectation of privacy, okay? And it's what is known as a police search, okay? So if a non-government agent is infringing upon your reasonable expectation of privacy, it's not, the Fourth Amendment doesn't apply to a non-governmental agent's actions, okay? Because the word search, the search has to be conducted by somebody who works for the government, like a police officer. Also, if a government agent is infringing if a government agent is engaging in some sort of activity, but it's not intruding upon a person's reasonable expectation of privacy, a search hasn't happened, right? And so we're going to go into more detail in a moment about like what that actually means. But the takeaway from this slide is that the Fourth Amendment the word search in the Fourth Amendment has a very specific meaning. It's a government agent's infringement on a person's reasonable expectation of privacy. It's a police search. So let's look at some examples. Okay, so here's a hypothetical, and I want you to think about whether or not the Fourth Amendment applies to the actions of the individual in this hypothetical scenario. So a security guard at a shopping mall follows a group of shoppers around the mall because they seem suspicious. The mall security stops the group, searches one of their backpacks, finds goods in that backpack without a receipt, and finds drugs. And then the security guard calls the police and turns the offender over to the police. So what do you think? Does this search violate the Fourth Amendment? In other words, if this happened to you at the local shopping mall, could you basically say that search is illegal because it violated the Fourth Amendment? Another way of looking at that is, does the Fourth Amendment apply to the security guard at the shopping mall? Well, based on the former slide, when we said that the definition of search has a very specific meaning, that it has to be a government agent that's engaging in that search, the answer to this is no. The Fourth Amendment doesn't apply to this scenario. In fact, it's not considered a search. Why? Because the security guard is not a government agent. The security guard works for a private company and is charged with providing security at a privately owned shopping mall. And so the Fourth Amendment does not apply to the actions of this security guard. So sorry, Charlie, those folks are out of luck, and the security guard is well within their rights to call the cops and turn you in for contraband and potentially stolen items. Now, that doesn't mean that the security guard couldn't be held accountable in other ways, right? That if the security guard is engaging in some sort of search that is really viewed as unreasonable, like, I don't know, following you into a bathroom or something, and you're hiding in a stall next to you, or if there's absolutely no reason at all for him to, look through your backpack, that you could sue that security guard for personal injury, right? Because they've invaded your privacy. But bottom line is the Fourth Amendment does not apply to the actions of a private actor, only to the government actor. The other aspect of the Fourth Amendment is that for the Fourth Amendment to be triggered or to apply to an action, that it needs to be in the context of that the search is that when a government agent is engaging in a search, that search must be of a place where one reasonably expects privacy. Okay. And there's no definition of one, like what a reasonable expectation of privacy is. The court, when somebody feels like they've been searched and they say, hey, there was no warrant and this is a private place, it's reasonable to think that this is a private place. The court will decide, well, is it reasonable to say that you would expect privacy here? And if the court says, yes, it's reasonable to think it's a private place, then the Fourth Amendment's been violated. But if the court says, no, there's no reasonable expectation of privacy, then the Fourth Amendment doesn't apply. And in fact, it's not even a search. So searching a private place triggers the Fourth Amendment. Okay. If the court says that the place is not private, a search has not occurred, and that the law enforcement don't need probable cause, they don't need a warrant to search because they're not searching a private place. The Fourth Amendment doesn't apply. But if the place is deemed private, then the Fourth Amendment applies. So let's take a look at a couple of scenarios, and you can think, hey, is it reasonable to assume that these are private places, and that if the cops need to search or intend to search these places, do they either need probable cause or a warrant? So let's take a look at some of these examples. Okay, so let's look at these different examples or hypotheticals and ask yourself, is it reasonable to think that what you're doing is private? Is there a reasonable expectation of privacy in these different examples? So let's say you're having a conversation with your friend on the couch in your living room inside your house. Is it reasonable to think that conversation is private? Yeah, it's very reasonable to think that conversation is private. That you're in your own home, that is probably one of the most private places. And, you're basically having a conversation that would be very difficult for somebody from the outside to hear what you were saying. So it's not that government couldn't intrude upon that private conversation. In fact, they can. They can get a warrant to place a wiretap on your phone. But in order to do that, they're going to need to have probable cause, and you're going to need to have a warrant, because there's a reasonable expectation of privacy with those private conversations in your home. What if you're having a conversation with your friend on a park bench in a public place, in a public park, for example? So let's say I'm sitting there on a park bench and I'm talking with my friend, and there are other park benches around me with people on them, and I'm talking with my friend, and then we start talking about some drug deal that we're planning, or a drug deal that's underway, and we're starting to have a conversation about that. Well, if cops think I'm a drug dealer and they know that I go to the public park, and they go and sit on the bench next to me in some, undercover gear where I can't identify them as cops, and they overhear my conversation, there's no reasonable expectation of privacy there. Cops don't need a warrant. They don't need probable cause in order to use that information to, get a warrant to search your place, because you're talking in an open public place. It's not a search. It doesn't trigger the Fourth Amendment. What about, and this relates to a case they talk about in your textbook. Let's say that you have, you're a drug dealer or anything. I mean, just let's say you have trash in your house, right? And that you put that trash in a trash can, and that trash can is on your porch. Would cops need, is that just abandoned property? You put it in the trash can, you're going to throw it out. Would cops need a warrant in order to go through your trash? Or would they not, because it's, there's not a reasonable expectation of privacy that the trash can on your porch is private. The court would say that would trigger the Fourth Amendment. If cops want to go through the trash on your porch, they would need a warrant and probable cause, because the porch is a private place. It's reasonable to assume that what goes on on your porch is private. And if cops want to go through and look on your porch, they need to have a warrant to do it. However, and this is the case that your textbook talks about, California v. Greenwood. This is a case where somebody puts their trash in a can and then they place that trash can on the street or in the alley for pickup. Do cops need a warrant to, to go through your trash in that circumstance? And they say, nope, you don't, because there's no reasonable expectation of privacy. That's basically abandoned property, that you've put that contraband in your trash can, or whatever, and then you put that trash can on the public street. It's a public street. There's no reasonable expectation of privacy that what's in that trash can is cordoned off from the public view. No, cops don't need a warrant to do that. Doesn't trigger the fourth. I don't want to spend too much time on this, but they talk about the police using a thermal device to collect temperature data, because they think that you're growing marijuana in your house. They said that that violates the Fourth Amendment, because there's a reasonable expectation. It's basically looking into your private space. They talk about using airplanes and drones to fly over the backyard to take pictures. They say that's not a search because it's airspace, and it's well within airspace is a public space. Police can use facial recognition technology in a public airport. It's public. They're looking at your faces. They're just using data collectors to analyze that data. So that wouldn't trigger the fourth. So those are just some examples to get you sort of thinking about the reasonable expectation of privacy. And here's just a quick overview of the information in your textbook where these are not considered searches, thus they don't protect the fourth. The Fourth Amendment is not triggered. And so searching abandoned property, we just talked about with the trash can. If you abandon your property, cops don't need a search warrant to go through that abandoned property, including anything that you might put in a trash can and place in a public area like a street or an alley. Searching an open field is not considered a search because there's no reasonable expectation of privacy. Even if you own that property, if it's just out in the public, an open field, that cops don't need to have a search warrant to search that open field. However, make sure that you understand the difference between the open field and curtilage. That curtilage is a property that it might be in the open, but it's clearly attached to your property, or it's clearly designated as your property, designated it's attached to your house. So porch, curtilage, your garage, curtilage, an outhouse, not like a bathroom, but like if you have a workshop and it's on your field, right, and it's fenced in, that's curtilage. It's always going to be sort of a debate about whether it's open field or curtilage, but make sure you're able to differentiate between those two things. And they talk about conducting flyovers in the case that where cops got a helicopter and they were really just doing a low level looking into people's backyards to see if they're growing marijuana. When you're reading the chapter for this week, it's just sort of like, what are cops going to do if like marijuana is legalized? Because so many of these search cases have to do with like searching people for marijuana. But the conducting flyovers that you don't need a warrant to look into somebody's backyard from airspace, because airspace, there's no expectation of privacy. It's public area, and they can use what they see in your backyard to establish probable cause and get a warrant. So as I'm always telling my students in my civil liberties class, that we have a lot of rights that are in the Bill of Rights, but those rights are not absolute. And that you might have the freedom to speak or the freedom to practice your religion, or in this case, you have the right to be private and be free from government intrusion. But just because you have the right to privacy doesn't mean that right is absolute. The right is not absolute. And so there's a lot of times where the government may need to intrude upon that privacy. And then there's good reason that they need to intrude upon that privacy. And so as I'm always telling my students in my civil liberties class, it's a balance, right? It's a balance between the rights of the individual and the interests of the government. And there are a lot of times where the government needs to, in order to achieve one of its major goals, and in this case, in order to make sure that crime is not taking place, and make sure that people are not being, subject to criminal activity, right? The government's well within its right to say that if they think somebody is engaging in criminal activity, they very well might need to enter into their private place in order to conduct an investigation, to hold that person accountable for engaging in criminal activity, and also just to make sure that the people in the community are safe, right? Because if you have criminals who aren't held accountable, then people aren't being held safe. And so the government may need to intrude into this privacy, but they need to do this in a way where they have a substantial reason to intrude upon that private, right? They can't just do it willy-nilly. They've got to have a good reason if they're going to invade your privacy. And the substantial reason is what's known as probable cause. And probable cause means that it's reasonable to believe, based on the evidence, that a crime has or is being committed. So for the government to engage in a violation of your privacy, to search you, they have to have probable cause. And the probable cause means that based on the evidence, it's reasonable to think that a crime has been committed. Now, keep in mind, probable cause is a higher standard than reasonable suspicion, right? If I'm a cop and I'm watching you drive down the street and you're swerving, it's reasonably suspicious. Like, what's going on in your car? Why are you doing that? Are you drunk? And so to pull somebody over, you need reasonable suspicion. But that's not a probable cause, right? That something suspicious seems to be going on. But then once you pull that person over and you say, hey, you're swerving, and the cop might think that that this person is drunk, and but then they do a little investigation, and this person doesn't smell like alcohol. They say, oh my God, this is a rental vehicle. I don't know how to work it. I was trying to change the lights, right? Well, you had reasonable suspicion to pull over, but there's not enough evidence. There's not enough evidence there to think that a crime has been committed. So there's no probable cause to arrest and then detain and search that vehicle, okay? So probable cause is a higher burden of proof than reasonable suspicion, but it's not as high as beyond a reasonable doubt. So let's say that, you're pulled over, reasonable suspicion because you're swerving, you unroll the window and you're drunk as a skunk, and then they do a blood test and you're like above the legal limit, and then you're going to be tried. Well, could very well be that that you haven't proved this beyond a reasonable doubt to convict that person of a crime. The defense attorney may submit evidence to say that this individual, sure, they were drunk, but they didn't know that they were drunk. They had been involuntarily intoxicated, right? We talked about that in terms of excuse defenses. And so that there's reason to think that a crime hadn't been committed because they didn't know that they had been intoxicated. So again, probable cause, higher bar of proof than reasonable suspicion, but a lower bar than to convict somebody of a crime. Now, probable cause is one of the elements that needs to be in place in order for police to get a search warrant and also to get an arrest warrant, okay? And so probable cause is one of the features that needs to be present in order to get a warrant. And so, when it comes to searching people, it's preferable that law enforcement get a warrant. And same with arrest. It's preferable that police officers have an arrest warrant. Although, as you're going to see in a moment, you don't always need a warrant to search, and you don't always need a warrant to arrest somebody. You'll read in your textbook, we're not going to spend a lot of time here, but it's just a quick overview, that there are 3 requirements that must be satisfied before a warrant can be issued. In order to get a warrant, that the warrant must be based on probable cause, right? That there's reasonable belief based on evidence that it's reasonable to think that a crime has been committed. Make sure you read in your textbook about all the different evidence that law enforcement can and cannot use in order to substantiate probable cause. And so that they can use information from their investigation, they can use information from an informant, they could use information from a victim, et cetera. They can use information in order to substantiate probable cause. But there's some things that cops can't use. Make sure you read about that in the textbook. A warrant must be issued by a judge or a magistrate. A magistrate is just any officer of the court. But usually law enforcement will present an affidavit to a judge basically saying that this is the information that we have, this is the evidence that we have, that there's probable cause to arrest or search somebody. The judge will look at that information and that evidence, and then based on that, they'll say, yes, you've satisfied probable cause, and so I will issue you a warrant. The judge is basically a check on the law enforcement, right? It's a check and a balance. If we let police officers issue warrants to other police officers, obviously that wouldn't be a proper check. And then finally, you'll read about in your textbook about particularity, that a warrant must be based on probable cause, it must be issued by a judge, and that the warrant has to be limited in scope. It doesn't have to be totally limited in scope, but on the warrant, it has to say that it has to designate what's being searched for based on the evidence that substantiates probable cause. And so you'll read in your textbook that the warrant has to be related to the crime that's taking place, the evidence that's used to support what crime we think is taking place. And so that if the evidence suggests that this person stole a boat, the particularity of the warrant has to be related to that. You couldn't search in dust drawers. You could search only in garages or places that have boats, right? And so the particularity designates what is to be searched. Do keep in mind that there's a plain sight exception in plain view, and so that even if cops have a search warrant that says they can only search some certain places, when they enter in a domicile, and let's say that there's a big pile of cocaine on in plain view on the coffee table, maybe that the search warrant wasn't search coffee table, but they walk in and they see that it's in plain view, and that doesn't need to be in the warrant to seize that contraband. Okay, so there are some exceptions to the need for a warrant, exceptions to the warrant requirement, and these are known as warrantless searches. So getting a warrant to search is preferred, but you don't always need a warrant, and it's oftentimes not practical to get a warrant, right? Getting a warrant takes time. If there's an emergency situation, if there's a threat to the safety of others or the threat to law enforcement, they can't wait to get a warrant, okay? And so there are times when it's reasonable to waive the warrant requirement, that you can search without a warrant, and that search can be legal. And we're going to be learning about warrantless searches in Lecture 2. Okay, thanks for your time, and I'll talk to you soon.